So, Nishant, tell us, law students are often taught about the importance of a preliminary decree and a final decree. Does that distinction actually matter in practice?
It does, it does. The distinction is always there, especially in matters relating to property, both partition suits as well as rent matters, because certain adjudication and certain issues are adjudicated upon by the court on a preliminary basis. Something like in a partition suit, we have people coming to court, maybe three parties, four parties, trying to define their right in the property. And therefore, the preliminary decree takes place when the court adjudicates upon their right and defines their right. So, for example, if there are four people and they want 25% share in the property each, then the court will at least define that if if the court adjudicates upon their issue, will define 25% each to their name, and then will pass an order, and that order will find its place as a preliminary decree to be enforced in terms of the rights of the parties.
And at that stage, what do you do? Would you appeal a preliminary decree?
The appeal, obviously, as many would know, depends upon whether you are happy or unhappy with the final order. And if you're unhappy, you are obviously advised, we at least advise, that you appeal the preliminary decree so that at least the initial issue based upon which the final issue will be decided upon is crystal clear.
And I mean, is it, if you're in doubt, what do? You would appeal it, basically.
Yes, we would.
And I'm presuming most of your clients would want to appeal it, right?
Not most of our clients. As I said, if the client is happy with whatever he's got or she's got, I don't think there's any requirement to appeal.
Okay. And so, what is the impact of not appealing it on the final decree?
Well, the fact that you do not appeal on the preliminary decree is pretty much as it would be on a final decree. I mean, the rights get defined, and that's it. They're set in stone, so you can't really change it after that.